Coffee time again, exposing the truth. Welcome to Coffee Time Again, exposing the truth. Dale at the microphone, the show that demonstrates how history repeats itself. He digs into the past, shows what happens, and how it is happening now. Follow the path of history to where it goes, then relate it to today to reveal the connections. The culture that forgets its history has no future. A history buff and loves to talk about it, going back as far as ancient Greeks and Egyptians and beyond. So grab your coffee, your chair, and listen to the show. Hope you enjoy.
Hello, USA. Welcome to the show. This is Coffee Time Again, where we expose the truth. My name is Dale. I am your host, and welcome into the world. Get your act together. You got a lot of trouble going on out there. Well, so do we, but we're working on ours, I think. Anyway, welcome to the show. Today we have Saul, a former assistant district attorney in New York, and now in private practice, specializing mainly in sex crimes. So we're going to get into that a little bit, and several other things that he's got written down here that I'd like to find out the answer to. So welcome, Saul.
Thank you so much, Dale. Pleasure to see you.
Yeah.
Pleasure to be on your show. What an honor for me.
Tell us a little bit about yourself, Saul.
So I am a criminal defense attorney. I do have a specialty in sex crimes. For some reason, that speaks to me. I feel that the underdog needs a lot more care than the white collar criminal, but I do represent both, obviously. And I am a litigator. It means I perform in front of a jury, in front of a judge. The reason I went into law is so simple. I wanted to be an actor my whole life, but there are too many out-of-work actors in Los Angeles and Hollywood. And I said, I can't, wait tables very well. I drop things. So the next best thing for me would be go to law school and to act in front of a jury, in front of a judge. And I get to talk to people every single day, and I get to talk to my clients. And I get to convince other people why my clients should be given the benefit of the doubt. And that is my job, to uphold the Constitution and to convince people that I'm right and that the other side is wrong. And it's very satisfying.
Very good. So you like your job. When we did our pre-interview, you made it very clear that you love your job.
I love this job. I wouldn't trade it in for anything. To be able to, first of all, every case is always different because every person is different. Every personality is different. So I get to see, a spectrum of people that most people don't get to see: the good, the bad, and the ugly. I see it all. And then I get to, form it into a story, into a narrative that I could give over to a judge or to a jury or even to a prosecutor, to show that my client is deserving of a second chance or my client is innocent, whatever the case may be. And everyone deserves the best defense that they could possibly get. And I always tell people, I'm not defending crime, I'm defending the Constitution, because we live in an amazing country. We live in a country that where you're innocent until proven guilty, and that really does mean something. And more people need to understand that. And until a jury or a judge comes back and says you're guilty, you are innocent. You are presumed innocent. So my take is I'm defending the Constitution. I'm giving over what I have been taught in jurisprudence, what I've been taught in constitutional law, what this country has that a lot of other countries don't have. And we're very fortunate to live in this free country.
I totally agree with you. Yeah. I'm a constitutional conservative. Here in Colorado, I belong to the Constitutional Conservative Party.
Mm-hmm.
And I'm a strong believer in the Constitution. My first 5 podcasts were on the Constitution, the first 10 amendments to the Constitution, the audio. But they still have a lot to say about how we're losing the battle to keep them. All of them, all 10 of them.
We really are, especially the Fourth Amendment and the Fifth Amendment. Fourth Amendment against search and seizure. There has been so many cases where I'm just shocked about the boldness of law enforcement to go ahead and to look in closed containers or to confiscate things and to search them without the benefit of a warrant. And I'm like, who's educating these law enforcement officers that they could do this? And it's my job to expose this to a judge and to explain to a judge that this is a violation. And then the second part is to say, and because it's a violation, it has to be suppressed. Because sometimes it's a violation and the judge says, well, the law enforcement was acting in good faith and therefore I'm not going to suppress it. That happens sometimes. And then, of course, the Fifth Amendment, where everyone hears on TV, you have the right to remain silent. Anything you say can and will be used against you. And I urge people, please, it's a right. Use it.
Yeah.
Use that right. Remain silent. You will not talk your way out of it. When the cops comes knocking on that door, it's not to have a cup of coffee with you. It's to get evidence against you.
Yes.
So
I found that
you
out the hard
use
way.
that right. Unfortunately,
I found
yeah,
that one out the hard way.
yeah.
So anyway, I want to ask some of these questions because they're really interesting. You did a good job on these, so because I really like them. And we just talked about the biggest mistake people make after being arrested and how they can avoid it. Shut
Yeah,
up.
exactly. I have a tagline that says, "Shut up and call Saul."
Yeah.
Um, you know, law enforcement has been trained to act extremely friendly and nice to you when they first encounter you, and it's part of their training, and it's a great training because they endear themselves to you and they tell you, we just want to talk to you. Let's have a conversation. Tell us what's going on. You have nothing to worry about. Everyone has something to worry about if law enforcement wants to speak to you. If the FBI, if Homeland Security, if the police, whatever it is, wants to knock on your door, have a conversation with you, or hands you a subpoena, the first thing you should do is say, I need an attorney. I don't want to talk to you. I want to have an attorney speak on my behalf. And then go meet with an attorney and have the attorney, meet with the law enforcement and deal with the issue. People think that they're going to save money and that they're smarter than the cop at the door. It doesn't work that way. Most of the time, law enforcement is talking to you because they know what the answers should be. And if you don't give them the answers that they want to hear, then they're going to arrest you on obstruction for lying to them.
Yeah.
And it's simple as that. They don't ask questions they don't know the answers to. They've already know the answers to it. They've already either seen your bank account or spoke to other witnesses or maybe even seen a video of something when they come and talk to you.
Yeah.
The best thing to do is to not say anything and say, I want to speak to an attorney.
Yeah.
And if you know you're under investigation, get an attorney immediately.
Yeah.
Find an attorney right away. It's worth the investment. Even if the investigation goes away eventually, it's still worth the investment to know that you have an attorney on speed dial, that when it comes time that somebody in law enforcement wants to have a conversation with you, you could just reach out to your attorney and say, I have an attorney. Here's his name. Here's his phone number. I don't want to talk to you.
Yeah.
And the law in this country provides that once you tell law enforcement, I have an attorney, they must stop questioning you. Mm-hmm. They must. If they go ahead and say, oh, what do you need an attorney for? Let's just talk a little bit. Whatever you say afterwards can't be used against you because they must stop questioning you once you say I have an attorney. And in my experience, most do.
Yeah, so that's good news that they do at least pay attention to that part of the Constitution that when you invoke your Fifth Amendment rights.
Right.
That's going to be a very important one.
It's honored. Yes.
Yes. I agree with you on that, Saul. You specialize in high stakes sex crimes. How do you defend clients when the stigma alone is career ending?
So again, it's defending the Constitution. It's not defending I never defend a crime. I will not defend rape. I will defend the Constitution against somebody being wrongfully accused or, being accused on evidence that should not be admitted into court. And everyone deserves the best defense that they could get. That's the bottom line. And I've had plenty of cases where it's either an exaggeration of the facts or clearly the person was innocent. And when you have cases like that, and you understand that some of your clients are innocent completely of the details of the accusations, it gives me more of an impetus to continue fighting for them and to fighting for others, because I'd rather have 10 guilty people on the street than one innocent person in jail. That's the truth. Yeah. Because an innocent person sitting behind bars is a horrible, horrible thing.
Yes, it is.
So I've had cases where my clients were accused of, let's say, a rape, and clearly he wasn't even in the area where it could happen. It was a case where a client was accused of raping his stepdaughter. Horrible, horrible crime. And I was able to prove, she was only able to give us like a 2-week window, but I was able to prove that in those 2 weeks, he never had the opportunity. He never had the opportunity to be there. And we did this through receipts that he had, including moving tickets that he had, concert tickets, gas station receipts. He went to get gas, 20 miles away from his home. We figured out how long it would take to get there and get back. He couldn't have been at home. She wasn't there. We had her school records when she was in school, and there just was zero opportunity. And the first thing he said to me when he came into my office is, I didn't do this. This is crazy. I know why she's accusing me. She's upset that I'm dating her mother, but it's like, I didn't do it. And there's something inside every criminal defense attorney where they just understand he's telling the truth. I didn't sleep at all until I got an acquittal. There's no question about it. I knew I had a heavy burden in front of me, but I got that acquittal.
Good. Yeah. What do you do when somebody is definitely guilty and walk in the office and say, I'm guilty, help me?
No problem. I will defend the Constitution, like I said, and we'll get you the best. And if you want to plead guilty, I have no problem, showing, defending somebody who wants to plead guilty and getting them the least amount of time possible, because everybody has, something good about them, and sometimes it takes time to bring it out. But I need to bring it out, and I need to understand it. Most people are not evil. Okay, a lot of people are sick, but most people are not evil. And if you're sick, you can get cured. If you're evil, you usually remain evil. So if somebody comes to me and tells me that they're a buyer of child pornography, or they're looking at child pornography and they got caught, most of the time that's a person who has maybe a sexual addiction or other addictions, and is not an evil person. And hopefully get that person into a treatment program, get the person better, get the person healthier. Show a judge and show a U.S. attorney or a district attorney how this person should be saved, how he's worthy of being saved, and get the least possible time, in jail for this person, so that they could live a fulfilling life when they get out. And it's going to be very difficult when they get out. There's no question about it. But
I had some in my groups when I was a drug and alcohol counselor. I had not a lot. I had maybe a half a dozen over 24 years. But I got a little bit of understanding on their how some of them were still saying they weren't guilty, and some of them were saying they were guilty.
Right. There comes a point where acceptance is the answer, as we all know.
Mm-hmm. Yeah, and I just accepted for what they said and treated the addiction.
Right.
Which is what my job was.
That's right. That's right.
So
yeah. So it's very rewarding. Even somebody who comes in and says, Saul, I did this, just get me the least amount of time possible. It's still a rewarding experience to work with that type of person, because I can get that person help. I can recommend, that's where my social worker hat comes in rather than my law hat. I mean, I need both. But in terms of getting the person into treatment and getting the right counselors and the right therapists, and sometimes even the right medication, and you see a complete 180 in some people, where they went to their whole life living in addiction to, being, free from it, and be able to live one day at a time, as a person free from this addiction, and enjoying life as best as they can, even if they have to face jail time.
Yeah. It's an interesting, the law is an interesting thing. When I was a kid, I wanted to be an attorney. I grew up to be a cook, and then a therapist. Now I'm a podcaster. So it didn't work out the way it was supposed to, the way I wanted it.
There's still time, Dale. You're still young.
75. What really happens when law enforcement has to see your phone at the airport?
Wow, that's a great question. So there's something called the border search exception, which basically says at a border of the United States, so for example, Canada, Mexico, or any international airport is considered an equivalent of a border, that you have no Fourth Amendment rights, that they could search whatever they want. Okay. And that's because we want to prevent, illegal goods from coming into the country, and because of the tariffs now that we have. So everything can be searched. So one of the things that could be searched, because they're looking for contraband, is your phone. Now, what could they possibly be looking on your phone for? What's the contraband? Child pornography is considered contraband. So somebody comes into this country, as usually go first to the first level of inspection is where you hand over your passport, and you might be flagged for what's called a secondary inspection. At the secondary inspection, you're taken into another room at the airport. They hold you onto your passport and they call you in and they ask for your phone. The next thing they're going to ask for is what the password of your phone, and they might say, can you share the password with me? Or they might ask straight out, what is the password? Everyone I know has been given over the password. Now, you don't have to, and we can get into that a little later, but everyone gives over the password and they start scrolling through the phone. The first thing they should do is they put it on airplane mode so that nothing can be downloaded from the internet. So they know that they have a phone without anything new coming onto it. And they right away, they'll go to the photos. They'll look at the photos. They're looking for photos of pornography, of specifically child pornography.
Yeah.
And if they find it, they're going to call Homeland Security that deals with this, and you're going to get arrested. At the very least, your phone is going to be confiscated, where they'll do a complete forensic search of the phone and then look for more evidence against you. This is what the state of the law right now is in New York, in New Jersey, and some other Florida and some other states as well, where a warrant is not required to do this search, to even do a forensic search. There may be case law coming out soon. The Second Circuit in New York has been looking into this, whether a warrant is required or not required. But right now, the current law is you don't need at least law enforcement believes you don't need a warrant, and you could search the phone for contraband. What you can't search the phone for is evidence of contraband, and that's an interesting technical issue here. There's so many interesting cases. There's a case of somebody who was a flight attendant who was accused of doing PPE fraud. She was basically, stealing money from the government during the COVID times, and they knew that she was flying from Colombia into Florida. So the agent who was investigating said, go grab a phone. Let's grab a phone and see what we can find on the phone. And sure enough, there was plenty of evidence of crime on the phone. But the Second Circuit said, no, you can't do that. You can't look for evidence of a crime. You can only look for contraband. And that case against her was thrown out, but not against her co-defendants, because they were able to use the evidence on the phone against her co-defendants, not against her, because they don't have a privacy interest in her phone. It's a fascinating area of law. I could talk for hours on this. And it's still evolving as we speak. But let's get to the password, right?
Right.
You're a U.S. citizen. You come into the country. They say, let me see your phone or let me see your computer. What's the password? You do not have to give them the password. You do not. You are not under any obligation to give them the password. And if you don't give them the password and you're a U.S. citizen, here's what's probably going to happen. They're going to keep the phone. They're going to confiscate the phone, and they might apply for a warrant later on, but they have to let you into the country. You're a U.S. citizen. They have to let you in. So you'll come into the country. You won't have your phone with you. You should go call a lawyer right away.
Yeah.
Okay. That's the first thing you should do when you get out of the airport, but that's secondary. Now, let's say you're not a U.S. citizen. If you're not a U.S. citizen, so they're going to say, well, you're violating our rules because we're allowed to check your phone and you're not cooperating with us by giving us your password. You're going back to whatever country you came from. And that may hold true for green card holders. It hasn't been tested yet. Mm-hmm. It may hold true for green card holders, but that is the risk you might take if you don't give over your password as a non-U.S. citizen. And people don't know that. No. People don't know that you could, turn off Face ID and not give over a password. And they may not be able to break into the phone. Chances are, given enough time, they will be able to break into the phone without a password. But by then you should have a lawyer, you should have a game plan and a defense if there's something on the phone that you don't want to be seen.
Okay. What about this one? It's in the Constitution, and I forget which amendment it is. It may be the fourth or the fifth. I think it's the fifth, that says all criminal cases, I can't remember exactly how it's framed, word for word, has to go before a grand jury.
Right. So we're talking about federal law since we're talking about the U.S. Constitution. Mm-hmm. So what a grand jury is, it's 23 people who get together in a room and hear a case and make a decision if there's enough evidence to hold the person over for the charges that they're being charged for. Not that they're guilty, not that they did it, not that they didn't do it, but there's enough evidence that there's a preponderance of the evidence to hold the person over for trial, okay? So a grand jury is presented with all these cases. And, there's a famous there's a famous saying by Justice Cardozo that says a grand jury could indict a ham sandwich.
Yeah, I've heard
because
that.
because it's just basically, a check mark. Yeah, I went to the grand jury. I gave over evidence. I got this piece of paper that says he's a he my person was indicted. The defendant was indicted. And what an indictment is, it just announces the charges against you. It could be one charge, 10 charges, 1,000 charges, whatever it is. The U.S. attorney will make out a game plan, how many charges they want to bring in the witnesses, bring in the evidence, show the evidence to the grand jury. And you need 12 out of the 23 to agree that there's enough evidence to indict the case. That's all it is. It's not proof of anything. It's proof that 23 people heard evidence.
Right.
There are, in state cases, some people do what's called a preliminary hearing instead of a grand jury, where the witness could then be cross-examined by the defense counsel. You see, in a grand jury, it's a total secret chamber, so to speak.
Yeah.
They used to call it the Star Chamber in England. And it's everything that happens in there is a secret. No one knows what's going on there. And eventually, if the case proceeds to trial, you'll get the transcript of the testimony of the witness that testified. But what you don't get is you don't get the grand jury instructions. And that's what the U.S. attorney told the grand jury about the charges. That the judge does get to see. And it's very important that the judge impartially read over those charges to make sure that they were presented correctly. Because if they weren't presented correctly, that indictment needs to be dismissed. And that's something that defense counsels don't get. It's a strange system. I believe my opinion is it's an ancient system.
It is.
I think we should have preliminary hearings rather than grand juries. The fact that it's so secretive, I think, is also an issue, that people don't know they're being indicted. People don't know what's going on. They keep it a secret. Even after the indictment comes out, it remains sealed until there's an arrest. So you could have a grand jury on week 1 and not make an arrest until week 10. Meantime, that indictment has been sitting in the courthouse sealed until week 10. And then, 10, 15 minutes after the arrest, the U.S. attorney will call up and say, unseal it. And now the whole world will know what you're indicted for.
I was curious about this, but that doesn't apply in state cases, only in federal cases where you have to have a grand jury?
So that in federal cases, you must have the grand jury. In state cases, depending on the state, and even in, let's say, New York and Florida, where I'm admitted to practice law, so you don't have to have an indictment. You could have what's called a preliminary hearing. There's a certain time frame when to have the preliminary hearing, and that's a witness will come in front of the judge. Let's say it's the arresting officer, and testify, I saw a white powdery substance be handed over to the defendant. I went ahead, I stopped the defendant. I believed it to be cocaine. I tested it. It was cocaine. And that's the whole case, to bring it forward to the stage where then they could have a trial. But at least in that case, the defense attorney gets to hear the testimony firsthand and question, how far away were you? Were you wearing glasses? Did you not have glasses? What pocket did he put it in? There's some level of cross-examination that could go on regarding the facts of why you believe this case should be, brought to a jury.
Okay, I was curious about that. How do cultural misunderstandings play out in courtroom dynamics or police interreactions? I bet that's a biggie.
Cultural misunderstandings, translating misunderstandings. A defense attorney really has to understand his client and understand the culture where his client's coming from. There are cultures where it's okay to do certain things, which a U.S. attorney or a district attorney will see as not so much a crime, but further evidence of a crime, and people won't understand it. There are words that people use in their dialect that when translated might sound like, wow, this person is a bad person. But in their dialect, that's just how they speak to one another. There's no negative connotations to it. It's just the way people speak. So a defense attorney needs to really sit down with their client for hours, not just once or twice for 10 minutes and get the facts of the case, but to understand the culture where the person's coming from, the person's background, how he was raised, where he was raised, what is unique about this person. And it helps in so many aspects of defending a case. Because if you have to go down to sentencing, you might want to talk about all that stuff in the background information as well. But it also helps in terms of what evidence is being presented against my client. Because if there's a cultural difference between how my client was raised and how the U.S. attorney is presenting this evidence, I want people to know about it. I want people to know that what you Americans see as a very bad thing, my client from Trinidad, this is not a bad thing. This is how people act, whatever it could be. I have a client that's Haitian that would slaughter chickens in his backyard as part of a religious rite.
Yeah.
Now, people would go ahead and hear that and say, "Wow, it's animal cruelty. How terrible!" But that's his culture. And that's how he was raised, and that's what he understands to be normal and okay. And it's my obligation to present that side of the story as well. But I need to understand that side of the story first before I can present it.
Yeah, you got to understand your client real well, whether they're Haitian or American.
Yes.
What's the role of truth in criminal defense? Is it about truth or the law?
Both.
Both?
Both are very important. I can't defend a lie. I would never present a case that I knew was not true, but I can present the law. And on the other hand, I could know that my client may have committed a crime, but the law is on his side because the evidence wasn't properly seized. The search wasn't good. The statements that he made was taken without Miranda warnings. So I could defend the client both ways. I could defend the client with the truth, or I could defend the client with the law. So both are very important.
Okay, it's interesting because I always thought it was about the law. Truth was not the important thing.
Well, just get back. So it's very interesting because with sex crime cases, we always say there's a defense called consent, where my client tells me this girl never said no. She never indicated she wasn't interested. She came on to me and we had sex. And now she's saying that I raped her. That is a very factual case because my client's not saying I never had sex with her. My client's saying I had consent and she consented to do what I had to, what we did. So that's a factual case, not a law case.
Yeah.
And then the question is, was there consent? Was there not consent? So that's what has to be analyzed.
She doesn't have to say yes, but she doesn't have. But she does say. But if she says no, you have to stop.
Right, and consent can be withdrawn at any time. And yeah, people have to understand that.
Yeah. Okay. Right. I was a bit curious about that. You've turned from ADA for many years in New York to a private defense attorney. What shifted your perspective?
Being a district attorney in New York County was probably the best job I ever had, quite frankly. I loved it. I loved every second of it. Unfortunately, I also like to live, in a nice house and send my children to private school. And it's very expensive to do that. And the DAs have a cap on their salary. So I had to stop, being a district attorney, assistant district attorney, in order to, fund my lifestyle.
Mm-hmm.
The shift was not very difficult at all. I mean, as a district attorney, you deal with defense attorneys all day long. So I knew the other side of the coin very well.
Mm-hmm.
But the truth is, my dream job was being that assistant district attorney. Every day I went home, put my head on the pillow, knew I was doing justice. And when the very rare occasion that I lost the case, the police officer or the FBI agent or whoever it was that I'm dealing with would come and say, "Don't worry, Saul, we'll get him next time." Yeah. People commit crimes all the time. We'll get them next time.
Yeah.
Whereas if I lose a case as a defense attorney, I'm miserable for weeks. I'm grumpy. Don't come and talk to me after a loss.
Doesn't sound like you lose too many.
No.
That's good. Why is silence sometimes your best defense, literally?
People think that they could be their own attorneys, and people think that they're smarter than the police, and they're not. And people think that they could lie to the police because the police will never figure it out or never know. The best thing to do is not to talk to them at all. Silence is your best defense. Speak to an attorney who has an attorney-client privilege with you, that you feel comfortable saying anything in the world to that person. Trust them with your deepest, darkest secrets. Let them know your deepest, darkest secrets. And you will find that if you do that, the attorney can protect you. You will not be able to protect yourself.
Yeah.
I've never seen anywhere where a client was successful in defending themselves, and just, speak to the police officer and get away with it. No, I've never seen a case where the police officer goes over and talks to a client, and the client, then they say, "Oh, you know what? You're right. You're innocent. Goodbye." There's always handcuffs afterwards. Always.
Yeah. I have heard that, and I'm sure it's true, as a matter of fact, because based on my own history dealing with clients myself as a therapist, that defending yourself as an attorney, you defending yourself would be a mistake.
So we call it having a fool for a client.
Yeah.
Yes. It's always a big mistake. Unfortunately, we see it all the time. I feel bad for these people that fire their attorneys in the middle of a trial and say, "I could do a better job." You can't do a better job. Maybe find another attorney, but don't try to defend yourself. There are things that attorneys could do that you just can't do on your own. And there's advice that attorneys will give you that you won't even think about on your own. It's very rare that I would ever let a defendant just speak to the judge on their own. Very rare. It has happened once in my career. It was a sympathetic case, and I felt that the client was smart enough and able, and prepped enough to actually speak to the judge. But I would never let somebody who's a client speak to the judge on their own. That's why they have an attorney, to speak on their behalf. That's what we're trained to do.
Okay. How should you vet a criminal defense when everything is on the line? How do you vet?
How do you
vet your attorney when everything's on the line?
It's a great question. What I like to tell people is you need to hire the attorney that you would be comfortable having over in your house for breakfast and sitting at your breakfast table and talking to you, okay? Just as a friend. You need to hire an attorney that is smart, that has the knowledge, that has the experience, but also has the ability to just talk to you, and you could say anything in the world to that person. Because the relationship between the attorney and client is an intimate relationship, not physically intimate, but it's an intimate relationship where they need to know everything about you, okay? And you need to be comfortable telling them everything about you, because that's how they're going to defend and win your case. So when you go to an attorney and you feel like, I have to hide something, I have to keep something a secret from this person, that's not the attorney for you. If you go to an attorney and say, I can tell this person anything, and I can tell this person my deepest, darkest secret. First of all, I trust the person that they won't use it against me or ever use it, quite frankly. Yeah. And the truth, the attorney-client privilege is built that I can never talk. No one can ever make me talk. You can't subpoena me into a grand jury and force me to talk. The attorney-client privilege is probably one of the strongest privileges we have in this country.
Yeah.
Okay. And until a client waives it, I can't say anything without that client's permission, ever. Okay. Yeah. No one can make me talk. So your secrets are totally safe with me. And by the way, that includes even talking to my wife, talking to my family, talking to my friends. No one ever finds out about my cases. Sometimes my name is written in the paper and my wife says, "I didn't know you were defending that person." I said, "You're right. You didn't know. We don't talk about it." You're right. That's just the way it is.
Yeah.
And that's the way it should be. Because I need to have the trust of my client to be able to talk to me. And you also have to be able to listen to your defense attorney and share with him your concerns. If you think that the defense is taking a different route and you want it somewhere else, you want a defense attorney who's actually going to listen to you, not tell you, "You don't know what you're talking about. I know what I'm doing. Leave me alone." Yeah, no, that's the wrong approach. A defense attorney who says, "Let me hear what you got. By the way, sometimes when I do listen to a client, they're right. They have a good approach. Unfortunately, sometimes they went to ChatGPT and give me the ChatGPT answer, and I could explain to them very respectfully why that's wrong.
Yeah.
Why ChatGPT is hallucinating, so to speak. But we have it both ways.
Yeah.
It's a great. It has to be a dynamic where you're comfortable with this person in all aspects of your life. All right, all aspects, whether it's the most private thing you've ever done in your life or the most public thing you've ever done in your life. You need to be comfortable that this person will defend you and honor what you're saying and come up with a strategy to work on it.
Okay. This is an interesting question to me, is how can podcasting or modern content help attorneys stay relevant and build trust?
Podcasting,
Yeah.
I'm hoping that people will see this. Other attorneys will see a podcast, potential clients will see a podcast, and understand that the most important thing to do if you're under investigation, or if the police already spoke to you, or if you've been arrested, is to find somebody that you could talk to and be comfortable with and defend you.
Mhm.
That's what's so important. And the way to get that message across is through podcasting. It's through talking to other people. I have a YouTube channel where you'll see me, talk about different aspects, a lot of small clips there, talking about different aspects of the law and how to defend people and how to talk to clients and be polite to clients and how to vigorously defend a case in front of a judge and a jury.
Yeah.
That's a key word, vigorously, because you don't want an attorney who goes in there who the judge yells at and sits down and says, "Oh, I'm really sorry." No, that's not what you want. You want an attorney who says, "Well, thank you for saying that, judge, and here's why you're wrong."
Yeah, that's an interesting conversation.
Yeah. And
Uh,
and have enough boldness to tell a judge, my job is to defend this person. Your job is to decide whether the law is on my side or their side. Don't come against my client. You don't have a right to do that, judge. You have a right to listen to the evidence and then make a decision on the law.
Last question, then I'm going to talk about other things. If you could fix one flaw in the criminal justice system, what would it be?
Wow, it's a great question. I think we need to do away with grand juries, quite frankly. I think that the whole system, because I know the history of the system, it starts with the Star Chamber and the secrets. I don't think it benefits either side. If you read grand jury testimony, it's so bare bones that there's no way the members of the grand jury understood what was going on. And if you read how a grand jury is charged, because remember, I was an assistant district attorney, I charged grand juries, okay?
Yeah.
You're basically reading them a textbook, a legal textbook. People don't understand that. People don't speak in those terms. That's not colloquial English.
No.
Okay. So it doesn't help at all. I think we have to move to more preliminary hearings. And the reason it's not done is because it takes so much time. And there are so many criminals, and there's not enough judges, and not enough courtrooms, and not enough prosecutors, and not enough defense attorneys. That's the issue. Quite frankly, my idea was to have the court systems work 24/7.
Yeah.
We have night courts from 6 p.m. to midnight. Work from midnight to 6 a.m. Why not?
Yeah.
There are plenty of night owls out there who'll be happy to take that shift.
Yeah.
Okay. And get enough judges and enough prosecutors to get these cases moving through the system much, much faster.
Right. Because the Constitution says we're entitled to a speedy jury. Speedy trial.
Speedy trial. Yes.
Yeah. I'm very familiar with the Constitution since 8th grade. What I like to do, I'm going to tell you, I usually wait till after the over, but I'm going to want people to know that this is what I do, is when I get this edited and it's ready to be published, I can send you a copy. And I have copyrights to it because I'm the one publishing it. However, I give you permission to use it as you want to.
Yeah, we spoke about this last time. Thank you so much. Really appreciate that. Yes.
Okay, just so you know that that's what I do, and I'll send it to you. It's called from WeTransfer.
Right.
So, What's the one thing that we haven't talked about that you think is important?
Let's think. Let's talk about the arrest process.
All right, sounds good to me. That's
Well,
happened to me 5 times. I've had 5 DUIs.
so you're the expert on it. You tell me.
Two of them were dismissed due to lack of evidence. On one of them, the arresting officer just flat never showed up for court, which is
That's
a good
good.
way to happen. And the other one, the arresting officer resigned the force and moved over to Colorado Springs, not Colorado Springs, whatever it is, the police state patrol academy.
Right.
She wanted to become a state patrolman, so she never showed up for the trial. So that got me out of 2 of them. I've got 3 convictions.
Yeah. Yeah.
Which is pretty close to felony.
Yes, it is. 3 strikes, you're out.
Yep.
But in terms of the arrest process, so there's 2 types of arrests. One is called a summary arrest. So basically, a police officer witnessed a defendant doing something wrong and goes ahead and takes the defendant, puts him in handcuffs, and processes the arrest. Okay? That's the summary arrest. Now, with a DWI, driving while intoxicated, that's how it happens. You get pulled over, you get pulled out of your car, they ask you to do a couple of field sobriety tests. They then maybe bring you back to the barracks and you do a breathalyzer test, and they have scientific proof that you were driving intoxicated. You get arrested. You then have to see a judge, and usually it has to be within 24 hours.
Yeah.
So you're sitting there detoxing, hopefully, and then see a judge, and you'll have an attorney. You're entitled to an attorney at that point. You must have an attorney at that point. And you have what's called an arraignment. That's the first time that the formal charges are being read against you. But before that happens, there's a lot of stuff in the background. What's happening is the police officer is taking all the evidence he has. If he has a video of the field sobriety test, he certainly should have the breathalyzer test results. And he's bringing that to a prosecutor. And he's telling the prosecutor, here's what I did. I saw somebody swerving, or I saw somebody driving erratic. I pulled them over. I took them out of the car. I looked at their eyes. I looked at these tests. I have this on video. I then brought him back to the barracks. He did a breath test, and this is what he did. And 0.08 is the legal limit. And he blew a 1.0 or whatever it was. And here's what I did. Then the prosecutor has to say, okay, based on what you're telling me, here are the crimes that I could charge this person with, and draws up what's called a complaint. Okay, this is the first time formal charges are being brought against that person. That complaint is what's read at an arraignment. And then the judge decides what to do with this person, because there's bail. And judge will make a decision whether to let you go ROR, which is, that you're on your own recognizance, that you come back whenever you want. Well, not whenever you want, when your court date is. Or we don't trust you that much and we have to set bail. So I'm going to take some money from you, okay? And if you continue being a good boy or girl and come back to all your court dates, you'll get this money back. What they don't tell you, by the way, is if you plead guilty, you get back that money minus a couple of percentage points. That they fail to tell you. But they take your money and you come back, all right? There's another type of arrest. This is where a complaint is sworn out against you, or you've been indicted by a grand jury and you don't even know about it, okay? So for example, if the police have determined that you committed a crime, let's take a robbery, okay? They have evidence, they have witnesses, and they went to the grand jury and they got an indictment against you, or they swore out a complaint against you, okay? Or maybe they even have a judge sign a complaint against you. And they know that every morning you go to Dunkin' Donuts to get your coffee at 7:30 in the morning. They could go to Dunkin' Donuts at 7:30 in the morning, see when you get online and say, excuse me, sir, can you step outside, and arrest you and start the process there. They already have the complaint, okay? So they're not meeting with the police, with the district attorney, rather, to draft the complaint because they already have it, or they already have the indictment. And then the next step is to see a judge and to get arraigned. And again, the same process of bail. You'll see this in what we call a dawn raid. This is where usually wealthy clients, so to speak, or people with means have committed a crime, sometimes a white collar crime. They get a knock at the door at 6 o'clock in the morning, and there's 30 agents all over the house. All right. They're all there. And they say, are you Mr. So-and-so? Yes, I am. All right, we have a warrant for your arrest, and usually they have a warrant to search your house as well. And they go in, they put you in handcuffs. If you're not wearing pants, they tell you to put a pair of pants on, put a shirt on, and they take you down as you are back to either the precinct or the FBI headquarters, and they process the arrest at that point, and then you go see a judge and have the arraignment.
That's what happens when, and I am familiar with that process.
Yes.
It's, to me, the most eerie sound in the world is a jail cell going shut.
Very scary sound. Yes.
It is. It is. The longest I was spent was 40 days on my third offense, third conviction. But that was the one that I quit drinking a year later.
And how soon after that did you stay sober?
See, that was in 88. I quit in 89, so it was about a year.
Okay.
Right.
So even after hearing that last jail door close, it still took a year.
Yeah.
See,
that's addiction for you.
So actually, I want to say that's how powerful this disease is.
Yeah, and it doesn't matter if it's alcohol, meth, cocaine, sex, gambling. It all works the same way.
Exactly. Very powerful.
You've got to remember that it's the way they work in the body, the way they work in the brain, what they do to you, what they do to your family, what they do to society. It's exactly the same. It doesn't matter what. I never really talked about drugs or alcohol in my groups because it doesn't matter. It's all the same.
Doesn't matter. Right. and the average person does not understand that.
No, they don't.
And the average judge doesn't understand that.
No.
I've had sentencing hearings where I walk in with the big book and I open up to the jaywalker story and I read it.
Yeah.
And I say, look at this. The guy can't stop jaywalking. That's my client. He either can't stop drinking. He can't stop drugging. He knows he's going to get hit by the trolley car and he still does it.
Yeah.
Because it's a disease. And that I view it's such a powerful parable in the big book that I use it in court.
Yeah. Good for you.
Yeah.
Yeah. Bill's stories are also awful powerful. It says in there, we are more than 100 men and women who have recovered, keyword there, recovered, from a seemingly hopeless state of body and mind.
If you could be brutally honest.
Yeah. Right. And it is, me, it's been one of the things that I use in my groups quite a bit because that key word, recovered. Because I consider myself to be a recovered addict. I'm still an addict. I could still go back. Not going through, but I could.
Yeah.
But I never think about it unless I'm talking about it. I never worry about it. I walk past the liquor store, don't even look in the window.
That's great.
Before I go in.
I just want to see if they still sell alcohol here.
Yeah, right.
Does it still smell the same?
Yeah. Now I don't even do that anymore. So
Good.
That's what we got about 5 minutes here.
Sure.
I think if I got my timing right. But you think we need to do away with the grand juries?
I think so. And another aspect is the bail situation. The whether to have cashless bail or not have cashless bail. It's an unfortunate situation where people who are wealthy get out of jail, and we're punishing people who have no money because they can't afford their bail.
Right.
Sometimes the bail is like $500,
right?
Which to most, now I shouldn't say most people, to a lot of people, okay, they'll come up with $500, but there are people that's the same thing as me telling you $100 million. They don't have the $500, and they don't have anyone who's going to put it up.
Right.
And it's crazy that they're spending months in jail over $500. It's just not fair. There has to be a better system, and they're building better systems around different states, in terms of cashless bail, whether it's a monitoring device, whether it's checking in every day to a probation officer or pretrial service officer, whatever it is. But it has to be a better system where we can't just say, if you have money, you can get out of jail. But if you don't have money, you stay in jail. That's a silly system. It doesn't help anyone.
No, well, bail has been around for hundreds of years, but I tend to not exactly disagree with you, but not totally agree with you either, because I've seen the rates on crime doing some of my research, and they're going sky high in these cities that have the cashless bail. Crime rates are just going nuts. Oh, you bet. Criminal comes before the judge. Judge says, I'll let you go, no problem. Just come back in 3 months. Judge says, you betcha, I'll be right. The defense says, you betcha, Your Honor, I want to get rid of this. I'll be there, you bet. Yeah, he's back in 3 months in cuffs again. That's my
Okay.
issue. The career criminal that does that, because they're not going to want to come back.
Right. Right. I hear. It goes both ways.
Yeah, it does. I'm going to shut off the video now and don't take off.
I'm not taking off.
Thank you for listening to the show. There are show notes and a place to comment at https://coffee-time-again.libsyn.com/website. He hopes that you liked what you heard and will tell others about him. Dale is attempting to get a following that both disagrees and agrees with him. He does not want yes men. If you disagree, wonderful. He is happy to have you here as a part of the Coffee Time Again team. Dale does not talk about the news of the day. He is attempting to give a history lesson that is just as important about what is going on in the headlines of today. Please do not hesitate to contact him. Just remember that Dale wants a clean show, meaning no cussing, name calling, yelling, or hate allowed. You can disagree with him and not be disagreeable about it. Support him and help keep this alive. https://glow.fm/coffee-time-again.